This video is about violence against first Australian women in the sense of intimate partner violence and the ways that intersectional discourses make those situations worse for our First Nations women. This slide also appears in the sexual violence lecture video, and this is a reminder that there are categorisations of various types of so-called law amongst Aboriginal scholars. There are the colonisers' laws, that is the Anglo-Australian laws which were imposed on Indigenous groups. There are traditional laws, and then what scholars call bullshit traditional laws. That's also used by the communities. A bullshit law is one in which an abuser or someone who commits an assault or sexual assault claims traditional law allows it in situations where that is not the case. And in most instances, it is not the case. There were laws in place in most Indigenous communities regarding respecting women and children and treating them appropriately. But due to the ignorance of white judges and juries, there have been successful claims that women in traditional communities accept and expect various forms of domestic violence and sexual assault, which has led in some cases to people being found not guilty, even though they clearly admit perpetrating the actions which are the basis of the claim. And you can read these quotes for yourself. If you have a look at a range of writings, and this one comes from Indigenous Australia for Dummies, then as they say, sexual abuse of women and children has never formed part of traditional cultural practices. Most traditional cultural laws and communities find it to be absolutely abhorrent, both amongst Indigenous men and women of all generations. However, there are people who've been exposed to abuse who themselves repeat forms of abuse, and in many cases these cycles of abuse were instituted when people were stolen away from their families or may have pre-existed, but not to greater degrees than in the European community. In addition, they note that the colonisation of Australia left a legacy of abuse in many Indigenous communities, and mention a situation where in 1898 the Northern Territory judge actually proposed laws to stop European sellers kidnapping and trafficking in Aboriginal children for sexual abuse purposes. And they also note throughout the book the very serious issues that things such as the stolen generation, the dispossession of people from their land, the incarceration of people into various types of communities against their will has done to Aboriginal communities, and has at times started cycles of abuse. As Berendt had pointed out in 2004, colonised men take on the behaviours and attitudes of the male colonisers, and in doing so have taken on various forms of perception that men should be superior to women and should use violence to ensure their superior status. She goes on to say, in this way, Aboriginal and non-Aboriginal men work together to establish the structure of patriarchy within the newly colonised societies. And she points out that that's not part of the original traditional laws of many of those cultures. For many Aboriginal women, leaving situations of domestic violence can be particularly fraught, more so than the situations of other survivors of domestic violence in some circumstances. There can be some really difficult situations arising out of multi-generational poverty and economic abuse. Also, deep concerns about reporting domestic violence as a result of racism towards Indigenous men and the fear that reporting to police will lead to disproportionate violence and abuse against men in the community. There's also very much the awareness of the impact of the stolen generations and on the necessity to keep families together when society as a whole and the Australian government in the past has worked so hard to break families and communities down. There can even be very real fears of state victimisation of people who are survivors of abuse, such as in the horrible situation of Ms. Du in WA, where Ms. Du was incarcerated and died while in lockup after a situation where she had fled domestic violence. She was arrested for minor matters not related to that, but that she came onto the radar of the police as a result of the domestic violence situation in that circumstance. So where can people go for help? The state has a very problematic role in our First Nations people's lives. If you look at the Bringing Them Home report about the stolen generation, it talks about the very real and shattering impact of the removal of generations of children from their families. Child protection now has been found to sometimes be overzealous in the removal of Indigenous children versus non-Indigenous children from their homes. Indigenous children are far more likely to be removed from homes where there is domestic violence, even if there is a protected parent and that protected parent is leaving the situation of violence. There is also substantially higher rates of children being removed more generally from homes with Indigenous parents than from homes with European descended parents. There's also very real issues around violence from the state to First Nations people. Historically, some of it was, as you know, absolute slaughters and appalling. But even in more recent times, there's been violence towards Indigenous people when they come up against the police, leading to not only massive numbers of deaths in custody since reports requiring the improvement of Aboriginal deaths in custody rates, but also ongoing fear of other forms of violence, which is more likely to be enacted against Indigenous people, according to many scholars. There can also be myths about the culture of Indigenous people, as I mentioned, that bullshit traditional law, so that domestic violence may be treated as unimportant or normal in Indigenous communities, such that people who report domestic violence cannot seek assistance. And some people may fear that they feed into discourses of the sort that led to the Northern Territory intervention. And the Northern Territory intervention, as you probably know, is an example of the race power in the Australian Constitution being used to make specific laws in relation to a particular race. The intervention has been exempted from discrimination laws, and it uses Australian Federal Police, Australian military and other federal personnel and staff to remove children and people from Northern Territory First Nations communities on the basis that they claim that children are at risk of higher levels of violence and sexual assault. They don't look at the fact that in many instances the violence and sexual assault against those children may come from non-Aboriginal sources, and that there have been findings that the rates of sexual assault against children in most communities affected were actually no higher than rates in similar Anglo-Australian or European Australian communities. There is very real fear that if someone speaks out against violence in their community, that could in fact expose the whole of the community to over-policing, deliberate intervention and removal of children a new stolen generation as such. So we have some really problematic responses, and having said that, though, there are situations where the police can be helpful and are supportive of First Nations people leaving situations of domestic violence. But there's a lot of invidious and difficult history that impacts choices to seek and how and where and when to seek safety. And the real issue around some of this is that intersectionality of oppression, that perception that because a person is not just Indigenous or a woman, but an Indigenous woman, that she is more likely to accept and expect domestic violence, that her culture promotes it, and that it is not a big deal, and at the same time so serious and systematic that her entire culture must be broken down to protect individuals within it. So it's a really difficult situation and awful for people caught in situations of domestic violence within First Nations communities.